Hey class, Mr. Stewart here. This is going to be the Week 7 Integrity video. For this week I'm going to be talking about Chapter 11, which is Punishment and Sentencing. And it's not a whole lot to say about Chapters 11 and 12 this week, but I do want to make sure that you understand kind of the four philosophical reasons for sentencing criminals. Because that really is what's supposed to guide the punishment process, as well as the application of the punishment in the criminal justice system. Doesn't mean that it always works that way, but that's what it's supposed to do. So I'm going to talk about that for a few minutes here this morning. And also, you shouldn't be seeing me, but you should be hearing me and seeing the PowerPoint here. As I'm speaking right now, you should be seeing the slide that says Learning Objective 1, list and contrast 4 basic philosophical reasons for sentencing criminals. Okay, there are 4 basic philosophical reasons for sentencing, and those are retribution, deterrence, incapacitation, and rehabilitation. I'm going to talk about each one of those. The first philosophical reason for sentencing is retribution, and this basically suggests to us that if you do wrong, if you break the law, if you engage in a criminal act, and you cause either some harm to someone or some harm or potential harm to society, then we're going to get back at you. That's this whole idea of retribution. It is that when we punish you, the state is getting back at you for this particular criminal activity that you have been convicted of, that you were engaging in. So this is more along the lines of old style punishment from back in the day, when it was more like getting even with somebody. I do something to you, you do something back at me. Well, you break the law, we're going to do something back to you, and that's what retribution is. And understand that there's still a little bit of that belief in sentencing criminals and punishing them today. Is we're going to get back at you. You've got to pay because you've done something wrong. So that's one of the philosophical reasons for sentencing. Another one is deterrence. And basically what deterrence is that it suggests to us that if we punish one person and we punish them severely enough, they themselves will not break the law again. And that is called specific deterrence. We're keeping that one individual offender from breaking the law again because we are punishing them severely and swiftly and certainly enough that it makes them think about breaking the law ever again. But we also make examples out of people, and when we make examples out of people, we'll punish you, and then we'll make that public, and that's supposed to be kind of a message sent to the public not to go out and engage in that same behavior, or you're going to receive punishment as well. And that's what we call general deterrence. An example of general deterrence is when the news covers a particular case, and then the person's found guilty and they get sentenced to prison. Then everybody says, well, I don't want to go to prison for that length of time, so maybe I don't need to go out and engage in that behavior. So that's a general deterrence. Specific deterrence is when we actually punish that offender to keep that offender from reoffending, such as if we give you the death penalty, we know that once we execute you, you're not going to offend any longer. If we put you in prison for the rest of your life without the possibility of parole, you're not going to be able to offend out in the free world any longer. So that's another philosophical reason for sentencing. It's deterrence, general deterrence and specific deterrence. Another philosophical reason for sentencing is incapacitation. And this is where we temporarily or permanently, depending upon the type of punishment that you receive, keep you from being able to commit crimes out in the real world because you have been sufficiently incapacitated. Now, we can selectively incapacitate people and we can collectively incapacitate people. And when we say incapacitate, we don't necessarily mean, strap them down to their bed, but simply the act of putting someone in prison incapacitates them from the rest of society. They can't be out in the rest of society committing crimes because they're now incapacitated. Then the fourth philosophical reason for sentencing is rehabilitation. This is one that probably the most money has been spent on in the last 150 years or so, and it's about preparing that person to get out of prison, so that they don't go out and they don't engage in that particular behavior again. It's really actually a fairly new practice, although the idea of rehabilitation has been around since the idea of imprisoning people. But actual efforts at rehabilitation is actually a fairly new practice as far as actually trying to prepare somebody to re-enter society. So those 4 things here are your philosophical reasons for why we punish people, why we sentence people to prison. And hopefully that makes sense to you. I want to talk for just a minute about determinate and indeterminate sentencing. It depends upon the state as to which type of sentencing that the state uses. A determinate sentence is when we say, if we give you a sentence of 10 years, that is your sentence, a 10-year prison sentence. An indeterminate sentence is going to be a sentence between, let's say, 2 and 10 years. So you're going to have a minimum of time that you will serve and a maximum time that you will serve. And depending upon, I guess, the attitude of the parole board and how well you play with others while you're incarcerated will depend upon, will determine how long you actually serve in prison. So not every state still uses indeterminate sentencing, although several of them do. Let's see. Yeah, indeterminate sentencing, penal code set a minimum and a maximum time that a person must spend in prison. You can be paroled at some time during that range, say that 2 to 10 year sentence. With determinate sentencing, typically the offender will serve exactly the amount of sentence time minus whatever good time they get. And what good time is most states, or a lot of states that use determinate sentencing, will give you 2 for 1 good time, and that means for every 1 day that you serve and you behave well, you get 2 days taken off of your sentence. Now that's a real good deal, actually. So that means theoretically you could go into prison with a 10-year sentence, and if you behave well during that first 5 years, you would be eligible for parole with half of your sentence done. Now, what this doesn't necessarily also say is that most states don't actually require an inmate to serve their full sentence. Most states require a minimum of 33% of the sentence to be served. So, if that's the case, you get a 10-year prison sentence. Right off the bat, you're going to only have to serve about 3 years and 4 months. And then, if you get good time during that sentence, you probably can be out in about a little over a year and a half. So that's really interesting to me how they figure that out, that you can serve a year and a half on 10 years, and they consider that punishment. In my honest opinion, that's not necessarily justice being served. Although if you're the inmate, then hey, 10-year sentence doesn't really mean anything to you. You can go in and do a little over a year, and hey, everything's good. So keep that in mind. All right, and that's exactly why Learning Objective 3 says why there is a difference between a sentence imposed by a judge and one than the actual sentence that's served by the prisoner, and that's because of overcrowding. It's because of the state corrections policy, whatever the type of sentencing that they have in that particular state. All of those things work together to actually come out to what the sentence will actually be. So let's talk here about Learning Objective 4, the 6 forms of punishment. Capital punishment, of course, that is the death penalty. Imprisonment, going to prison. Probation. Probation is, many people get probation and parole confused. Now, probation is simply where, in lieu of going to jail or prison for your crime, you have been convicted of it and you have received a sentence, but in lieu of actually going to jail, you are given probation, which basically is a fairly restrictive set of rules and guidelines that you must abide by for the length of time that you have been put on probation. And if you violate those rules and regulations, you can be rearrested. If you are found guilty of violating that probation, you can be sentenced to serve whatever the original jail sentence that was suspended for the probation was. So let's say you go, you get arrested, you get convicted of something, and you get a 10-year prison sentence. And let's say the judge says, I'm going to suspend that and I'm going to put you on probation for 7 years. And let's say during that 7 years, let's say 6 years out of that 7, you've done everything you're supposed to do. And let's say something happens during that 7th year, that last year on probation, and you get arrested. They violate your probation, the terms of your probation, and the judge could send you to prison for 10 years right then. So many people don't like probation because they say the probation officers are consistently and constantly looking for a reason to violate people, which in turn just basically all it does is put off a prison sentence. In some cases, that's the opinion of a lot of people. Another type of punishment is fines. We'll stand in your pocketbook, if you will. We'll cost you some money. The bad part is a lot of criminals don't have any money to pay fines with, so a lot of times they will suspend the fine just because they know that the criminal can't pay it. Another type of punishment is restitution or community service, and that's basically making good whatever damage that you caused out there. If you broke something or destroyed something, pay to have it fixed. Or in lieu of that, maybe we put you out there doing community service work so that people see that you are in the custody of the state or the county or whatnot. And it's a bit of public shaming involved with that community service work as well. And then the last form of punishment is called restorative justice. And this is something that reared its head in the late 60s, early 70s. It kind of died out, but it has made a pretty good comeback nationwide in the last several years. And what this suggests to us, what restorative justice suggests to us, is that there has to be some healing and forgiveness in regard to all parties involved, and accountability for those who engaged in the wrongful act. So let's say you go out and you kill somebody, and you get a prison sentence. Well, if the court or the state believes in restorative justice, then you would have the victim's family, and you would probably have a sit down at some point while you're serving your prison sentence, and they would tell you that they forgive you and that they want to move on with their life and put this behind them, so that they have closure. And then in return they're expecting you to say, yes, I did this, I'm remorseful for this, I made a bad decision, I would not do this type of thing again. And so that also gives that defendant some closure to it. And then a lot of times in those cases they will even cut the sentence short if they believe that everybody has reached some point of healing in regard to this. I used to be almost dead set against restorative justice, but it started to grow on me a little bit, especially in some crimes, because we know that the criminal justice system in some cases harms defendants, and once they've been into the system for a long period of time, the likelihood they're going to be successful afterward is very low. Restorative justice basically allows for their success rate to be increased so that they don't go out and commit another crime. All right, I'm not necessarily as worried about Learning Objective 5 here. State has input in sentencing decision, list of factors that determine a sentence. It's up to the judge, and it's up to evidence presenting at the sentencing hearing to determine what the sentence is. Now, most judges have a set of guidelines that they have to go by. There is a minimum and a maximum sentence for a lot of crimes, and so the judge will ask for a pre-sentence investigation report so that they can have as much information about the defendant as possible before they pass judgment on them. They will receive recommendations from the prosecutor and the defense attorney as to what the sentence should be. And in some cases, they actually ask the jury to weigh in on the sentencing. especially in capital cases. If the jury says death penalty, then the judge will give them the death penalty. If they say life, the judge will give them life. Some of the factors that affect sentencing is the seriousness of the crime. I mean, typically the less serious the crime is, the less the sentence will be. Aggravating or mitigating circumstances, such as are you a repeat offender or are you a first-time offender? You know, a first-time offender might be considered a mitigating circumstance. You've never been in trouble before, so therefore we're not going to sentence you as severely this time. Or it could go the other way. If you are a frequent flyer in the criminal justice system, that's an aggravating factor. We can use anything you've been convicted of up to that point as an aggravating factor to increase your sentence now, because apparently what we've done in the past just didn't work. And also the judicial philosophy. Some judges are law and order judges. Some judges are rehabilitation judges. So it just depends on what that particular judge wants to do to a certain degree in regard to how they're going to sentence somebody. Why has sentencing reform occurred? Because we have a lot of disparity in sentencing across the board in this country. It doesn't, depending upon, even in the same state, you could have two defendants who are charged with the exact same offense, but one judge may sentence them to a really long sentence, another judge may sentence them to a really short sentence. So there is some disparity. There's also some crimes that have mandatory sentences, and there's not a whole lot of leeway for the judges. So there's been some movement in the past few years to kind of try to reform sentencing to a certain degree and allow judges. I guess some judges want more leeway, and other judges want it to be more controlled, so that they don't have a whole lot of leeway. And I guess it's kind of 6-1 and half dozen the other in regard to that. So I mean, I don't really necessarily have an opinion on really what we should do in regard to sentencing, other than I don't really care as long as it's fair, honestly. There is discrimination in sentencing. Typically, women have been given lesser sentences than men historically. We're seeing that change to a certain degree as well. We also started using victim impact statements in regard to sentencing, which basically allows the judge to hear from the victim's family, to know that what the impact of this crime has had on them, and they will take that into consideration in regard to the sentence. And if the victim's family wants a really long sentence, and they've been affected by this crime, a lot of times they will go along with what the victim's family wants, because somebody's got to pay. And that the state wants their pound of flesh, if you will, from the defendant. So just keep that in mind as well. All right, and I did tell you that it's a bifurcated process between conviction and sentencing. Typically, it's two separate proceedings. You'll have the fact-finding stage, which is the criminal trial, and of course, and this really has to do with the death penalty. That if the defendant's not found guilty or guilty of a lesser offense, then of course there's no death penalty is going to be applied. If they are found guilty, you move to stage 2, and stage 2 is when you actually have a sentencing hearing. With the sentencing hearing, each side gets to present evidence that could affect whether that person gets the death penalty or not. I mean, just because they're asking for the death penalty doesn't mean they get it. But it is a bifurcated, which means a two-stage process there. All right, and then of course there's always some issues in regard to death penalty debate. Your book does a pretty good job of talking about those, and if you go out and you look at some of the current events in regard to what some people are calling botched executions, and many people are taking the drugs used in lethal injection to court, saying that we need to do something different. Some states are now going back to using the electric chair. I believe the state of Washington still allows you to hang a defendant. The state of Utah allows a death penalty to be carried out by firing squad, if you wish. So I think Gary Gilmore was the last inmate to die by firing squad in Utah. You can Google that. It's pretty interesting. So I mean, that in a nutshell is chapter 11, and that's where I'm going to leave off this integrity video for this week. Just chapter 12 is also pretty straightforward also. And if you have questions, problems, or concerns, please let me know, and I will be trying to get caught up with responding and grading here in the next few days. Have a good week. Bye-bye.